ladies and gentlemen, we affirm that War and Emergency Powers Acts, beginning in earnest with the Trading with the Enemy Act of 1917, escalated under the Emergency Banking Relief Act of 1933, and perpetuated through countless subsequent statutes, have corporatized the United States government, replacing constitutional governance with a commercial, administrative, and statutory regime that treats its citizens not as sovereigns, but as subjects within a corporate jurisdiction. Let us be clear. We are not claiming that the United States was privatized like a business on the stock market. Rather, we argue that the legal structure and behavior of the federal government has shifted from that of a constitutional republic to that of a centralized commercial corporation, where rules are made by executives and enforced through administrative codes and contract law, rather than derived from the natural rights framework of the original Constitution. I, the foundation, emergency powers, and the abandonment of constitutional process. The Trading with the Enemy Act of 1917, passed during World War I, gave the President sweeping powers to regulate all financial transactions with declared enemies. But this wartime authority was later extended to domestic governance in 1933 under FDR, when the United States was not at war with any foreign power, but with an economic depression. The Emergency Banking Relief Act of 1933 amended TWEA to allow the President to declare a national emergency and seize control over banking and currency, even from U.S. citizens. In doing so, the federal government declared the American people themselves to be potential economic enemies under emergency jurisdiction. This marked the moment when the Constitution was effectively sidelined, and executive authority took center stage, with Congress abdicating its lawmaking role in favor of emergency decrees and regulatory agencies. 2. Municipal incorporation and the shift to commercial jurisdiction. In parallel, we must consider the District of Columbia Organic Acts, including the Act of 1871, which created a municipal corporation for the federal capital. While defenders argue this was only administrative, the reality is that this act laid the groundwork for governing via corporate structure rather than Republican representation. Today, the United States government operates with many attributes of a corporate entity. It has a federal register like a corporate policy manual. It assigns identification numbers to citizens via Social Security, akin to commercial accounts. It regulates through Uniform Commercial Code, UCC, the law of contracts, not rights. Courts no longer apply the common law of the land, but the statutory codes of a commercial jurisdiction. Third, the result, a corporate-state hybrid, not a constitutional republic under this regime. Your rights are converted into privileges, subject to licensing, fees, and revocation. You do not deal with judges of the law, but administrative officers enforcing corporate policies under color of law. The presumption is that you are a beneficiary or debtor of the corporate state, not a sovereign under natural law. Even courtroom symbolism reflects this shift. Gold-fringed flags, absence of state banners, and Admiralty-style layouts reflect a foreign jurisdiction, one where statutory contract law supersedes constitutional protection. And let us not forget the National Emergencies Act of 1976, which was supposedly enacted to limit perpetual emergency rule. In reality, over 40 active emergencies are still in effect today, and Congress has never truly revoked any of them. The executive branch rules with continuous emergency powers, in violation of the Constitution's guarantee of separation of powers. 4. Conclusion. We are not arguing semantics. We are pointing to a documented, systemic transformation in which the United States government, via war and emergency powers, has transitioned from a limited republic of delegated authority to an unlimited commercial state that governs by corporate contract and administrative enforcement. The Constitution has not been repealed, but it has been functionally replaced in most matters of law, finance, and citizenship by a structure that looks more like a corporation managing human capital than a government protecting God-given rights. We affirm the resolution.
Ladies and gentlemen, we stand in firm opposition to the proposition that War and Emergency Powers Acts have corporatized the U.S. government in any way that has fundamentally altered its constitutional character. While it is true that the federal government has, at times, expanded its authority in response to national crises, the structure, legal foundation, and accountability of the United States remain grounded in the Constitution of 1787 and the republic it established. We reject alarmist misinterpretations and selective legal readings that suggest America has become a corporation in any meaningful or legal sense. Let us clarify the issue with precision, not conspiracy. I, Emergency powers do not equal corporate governance. Yes, Congress has enacted emergency powers statutes, such as the Trading with the Enemy Act of 1917, the Emergency Banking Relief Act of 1933, the National Emergencies Act of 1976. But these laws were created, passed, and upheld through constitutional processes by the legislative branch, often with sunset clauses, review mechanisms, and judicial oversight. Emergency powers are not unconstitutional per se. They are explicitly contemplated in the Constitution. Article 1, Section 9 provides for suspension of habeas corpus when in cases of rebellion or invasion, the public safety may require it. The founders understood the need for flexibility in extreme circumstances. That Congress granted the executive more authority during crises does not dissolve the Constitution. It simply reflects the reality that governments must sometimes act quickly to address national emergencies. These powers have been constrained by law and subject to challenge in the courts. If the people feel those powers have been abused, the ballot box remains open, and the separation of powers remains intact. 2. The claim of corporate governance is a semantic illusion. Much of the claim hinges on misunderstanding the term corporation. The District of Columbia Organic Act of 1871 created a municipal corporation, a form of city government, not a private business. Municipal corporation is a standard legal term to describe how cities are structured. New York City is a municipal corporation. Los Angeles is. Washington, D.C. is. But no one suggests these cities have ceased to be part of the Republic, or their citizens lost their rights. The United States has never been incorporated as a private entity under any state or international law. There is no charter, no shareholders, no articles of incorporation. The U.S. government is not listed on Dun & Bradstreet as a corporation, at least not in any capacity that negates its status as a sovereign nation-state governed by a constitution. Claims that the use of the Uniform Commercial Code, UCC, or the assignment of Social Security numbers transforms citizens into corporate entities are legal myths. The UCC is a harmonized body of law for commercial transactions, adopted by all 50 states. It does not override the Constitution, nor does it replace common law or criminal law. It's a commercial tool, not a governmental regime. Third, constitutional governance remains operational. Despite claims to the contrary, the U.S. Constitution remains the supreme law of the land. Courts still review laws for constitutionality. Citizens still retain rights under the Bill of Rights. Public officials are still sworn to uphold the Constitution, not a corporate charter. If the U.S. had truly been corporatized, none of this would be possible. Citizens would not be able to sue the government and win. Courts would not strike down laws like the CDC eviction moratorium or overreaching vaccine mandates. States could not pass and enforce their own laws. The existence of checks and balances, court decisions, whistleblower protections, and political opposition proves the system is not only alive, but functional, even if imperfect. V. Addressing the gold-fringed flag and courtroom claims. The idea that a gold fringe on the American flag signifies admiralty or corporate jurisdiction is simply false. Courts, the U.S. Army, and flag experts have consistently affirmed that gold fringe is purely ceremonial with no legal implications. Similarly, the structure of courtrooms, docket formats, or judge titles does not signify secret corporate law. They are administrative customs, not markers of a hidden corporate government. V. Conclusion. Have emergency powers expanded federal authority at times? Yes. Have those powers always been used wisely? No. But that is a political question, not a legal proof of corporate usurpation. The United States remains a constitutional republic, governed by elected officials, bound by the rule of law, and accountable to its people. Claims of corporatization misunderstand legal terms, misinterpret administrative practices, and ultimately distract from the real issue: how we, the people, hold our government accountable within the system our Constitution provides. We respectfully negate the resolution.
The negative side argues that because the Constitution remains in place and elections continue, the government has not been corporatized. But retaining the outer shell of a republic does not mean the core functions of that republic have not been hollowed out and replaced with something else. The claim is not that the government dissolved, but that it transformed in nature, from a servant of the people to a corporate administrative entity operating under perpetual emergency powers and commercial law. 1. The Constitution was not repealed, it was bypassed. It is true that Congress enacted the Trading with the Enemy Act and the Emergency Banking Relief Act through constitutional procedure. But once passed, these laws created mechanisms of executive control that sidestep checks and balances. Presidents now govern not by Article 1 laws debated in Congress, but by executive orders, agency regulations, and emergency declarations that bypass normal due process. If the Constitution is truly supreme, then why has the U.S. been under at least one active national emergency continuously since 1933? That is not limited constitutional governance. That is administrative control under color of law, often without meaningful congressional restraint or judicial remedy. 2. The municipal corporation model was just the beginning. The negative tries to isolate the 1871 D.C. incorporation as a minor event. But that municipal framework has become the template for modern governance: centralized authority, administrative departments, and top-down regulation of citizens like employees or debtors. The rise of administrative law, enforced by unelected bureaucrats in non-Article III courts, supports this. Today, many Americans interact with agencies, not judges or legislators, for matters involving family, taxes, land, and business. That is not a constitutional republic. That is a bureaucratic corporate machine. 3. Corporate influence and lobbyist corruption. Confirm the merger. Let's speak plainly. Who really writes the laws? More often than not, it is corporate lobbyists. Fortune 500 companies spend billions lobbying Congress to write, shape, or stall legislation in their favor. Regulatory agencies are filled with revolving door executives from the same corporations they're supposed to oversee. This is not hypothetical. Defense contractors influence military policy. Pharmaceutical companies lobby the FDA. Tech giants help draft surveillance and data laws. When private interests write public policy, the government is no longer a neutral guardian of rights. It becomes a commercial enforcer, protecting wealth and influence, not liberty. 4. UCC, legal presumptions, and the rise of the legal fiction. The negative dismisses the Uniform Commercial Code, UCC, as benign, but this ignores the transformation it represents: a legal system built on contracts, not natural rights. Citizens today are treated not as men and women under God-given authority, but as legal fictions. Corporate entities identified by all-caps names, taxpayer IDs, and regulated through commercial presumption. You do not opt in to this system. You are presumed to consent by participation, using Federal Reserve notes, registering your vehicle, filing tax forms. Every aspect of your life becomes a series of contracts, administered by agencies, enforced by tribunals, and judged not by truth but by procedure. This is the operational essence of corporatized governance. 5. Rights are now privileges, licensed and controlled. Today, you need a permit to protest, a license to travel, and permission to transact. The very exercise of your rights is contingent on government approval. This inversion, from inalienable rights to regulated privileges, is a hallmark of corporate administration, not constitutional republics. In a republic, government must ask permission to act. In a corporatized regime, you must ask permission to live freely. Conclusion. The negative assures us that because we still vote and the courts still operate, we have not lost the republic. But rituals of government do not preserve its substance. Through war and emergency powers, corporate influence, and administrative control, the United States has been transformed into a government that regulates by commercial contract, governs by perpetual emergency, answers to corporate interests, and presumes your consent through silent adhesion. That is corporatization in both spirit and function. We reaffirm the resolution.
The affirmative has presented a compelling narrative. but it's built on conflating systemic dysfunction with constitutional dissolution. Yes, the modern federal government has expanded. Yes, corruption and influence are real problems. But that does not prove the U.S. has become a corporation in the legal or structural sense. The system is distorted, not replaced. Let's respond point by point. 1. Emergency powers are constitutional, not corporate. The affirmative rightly criticizes the abuse of emergency powers, but abuse does not prove transformation into a corporate structure. The Constitution explicitly contemplates emergencies, see Article 1, Section 9, and courts have consistently held that Congress has the authority to delegate emergency responsibilities to the executive, so long as those powers are limited and reviewable. The National Emergencies Act of 1976 was a reform effort to bring oversight to these powers. Could it be stronger? Yes. Has it replaced the Constitution? No. Emergency declarations are still executive actions that can be challenged in court or revoked by Congress. There is no evidence that these powers have corporatized government. At most, they show centralization, which is a political problem, not proof of a hidden commercial regime. 2. Municipal incorporation, national corporatization. The 1871 Act that incorporated the District of Columbia created a municipal government, just like any city in the country. It didn't convert the United States into a commercial corporation. There is no federal statute, court ruling, or constitutional amendment that legally converts the U.S. government into a private entity. It still operates under 3 branches of government, with separation of powers, through representative elections, bound by state and federal constitutions. Administrative agencies exist in every modern government. That doesn't make them corporate. Efficiency isn't the same as privatization. 3. Lobbyist influence is a political corruption problem, not evidence of corporate takeover. Lobbying and corporate influence are serious problems, but they don't prove legal corporatization. They demonstrate a capture of policymaking, not a transformation of government's legal identity. In fact, the very fact that we can criticize, protest, and sue the government over lobbying corruption shows that constitutional processes still function, however imperfectly. If we were under a corporate regime, none of that would be allowed. The First Amendment still applies. Whistleblowers still speak. Courts still block unlawful policies. Citizens still win lawsuits. The affirmative argument here is passionate but misdirected. Corruption does not equal corporatization. 4. The UCC does not govern citizens, it governs commerce. The Uniform Commercial Code, UCC, is a model code adopted by states to regulate contracts, secured transactions, and commercial paper, not constitutional rights. It governs business, not citizenship. You cannot be tried or fined under the UCC unless you're engaged in a commercial transaction. Traffic violations, criminal charges, family law, none of this falls under UCC jurisdiction. Claims that Social Security numbers or all-caps names create a corporate fiction are pseudo-legal myths, unsupported by any court in the country. Courts reject these theories as frivolous because they lack legal grounding. 5. Rights are still protected, even if inconvenienced. The affirmative says our rights have become privileges. That is demonstrably false. Yes, you need a license to drive, but that's because driving is regulated for public safety, not because your natural rights have been stripped. You do not need a license to speak freely, worship as you choose, refuse unlawful searches, petition the government, own private property. You can sue the government, vote out your representatives, and protest on the steps of the Capitol. These are not the privileges of corporate employees. They are the rights of citizens under a constitutional republic. Conclusion. Let's be clear. The affirmative has highlighted serious issues: executive overreach, regulatory sprawl, lobbyist corruption, and systemic legal complexity. But none of these prove that the U.S. government is now a corporation in the legal, structural, or functional sense. We still have a written constitution, 3 branches of government, state sovereignty, judicial review, free speech, free elections. Yes, we must reform. Yes, we must resist overreach. But we must do so within the framework of a still living constitution, not by declaring it null and void in favor of speculative corporate metaphors. We respectfully maintain our opposition to the resolution.
Let's start with the elephant in the room. 2020 was proof that our votes no longer hold binding power. Courts refused to hear election integrity cases, major corporations controlled the narrative, and emergency rules changed voting procedures overnight. That's not constitutional self-governance. That's corporate-managed perception. The people's voice has been reduced to a corporate suggestion box, acknowledged only when it suits the agenda.
Respectfully, that's an overstatement. Every state certified its results under state constitutional processes, and over 60 lawsuits challenging those results were heard and rejected by courts, including the U.S. Supreme Court. The fact that many people disagree with the outcome doesn't invalidate the process. Elections in 2020 were more accessible than ever, and millions participated. If votes were meaningless, why did both sides spend billions campaigning for them?
Because public consent is the fuel that powers the illusion. The corporate-state hybrid needs people to believe they have a say, but decisions are made upstream, from BlackRock, Pfizer, Google, Citadel, and the defense industry. The same unelected bureaucracies remain in power regardless of who's in office. Elections change the face, not the policy. Biden didn't roll back most of Trump's executive structure. Trump didn't drain any swamp. The machine stays intact because it's not a republic. It's a managerial corporation.
That's an easy narrative. But where is the evidence of actual corporate control over election certification? You're pointing to influence, not control. Yes, corporations have power. But the people still ousted Trump and elected Biden, not because of some master plan, but because people voted, ballots were counted, and states followed their rules. Don't conflate dissatisfaction or lack of reform with proof that voting is dead. That cynicism helps the system by discouraging engagement.
But it's not just about the votes. It's about the jurisdiction. Elections are administered by corporate-style agencies, not by direct representation. Citizens don't have standing to audit ballots or demand transparency. Even local officials are indemnified and protected like corporate officers. It's all layers of liability shields, NDAs, and procedural walls. When the people are told they lack standing in their own government, that's not a republic. That's corporate governance by legal insulation.
Standing requirements exist in all legitimate court systems to prevent frivolous or redundant claims. That's part of judicial integrity, not corporate secrecy. Moreover, citizens do have audit rights. Many states ran recounts, hand audits, and third-party reviews. But you can't demand endless litigation just because the result was unpopular. That's not principled civic engagement. That's selective belief in the system, only when your side wins.
We can't ignore the fact that emergency declarations shape the rules of voting, just like they shape banking, healthcare, and policing. When governors and bureaucrats, not legislatures, change the rules midstream, the people aren't governing anymore. They're being governed under emergency statutes and executive orders, the exact hallmarks of a corporatized, top-down system.
Then change the laws. That's what state legislatures are for. Many states have passed new voting laws since 2020. If anything, 2020 proved that election systems are dynamic, flawed, and fixable, not corporately controlled. A real corporation doesn't invite reform. But this system, however flawed, still lets the people speak, if they're willing to stay engaged.
Let's address the real issue here. 2020 wasn't just a political event. It was a revelation. It pulled back the veil on how media, tech, pharma, and government all operate as one consolidated corporate organism. You had social media censoring dissent, pharmaceutical companies writing public health policy, corporations deciding speech rights, and emergency powers suspending constitutional protections. That isn't flawed but fixable. That's systemic. And don't forget the timing. 2020 vision. A clear symbolic exposure of how corrupt the system is. What we saw wasn't a hiccup. It was a diagnostic. The body politic is sick, the organs are corporatized, and the Constitution is on life support.
I won't deny that 2020 was a crisis moment, but every republic in history has faced moments like that. What matters is how the system responds. The courts functioned, states adjusted laws, investigations happened, even if they didn't go the way everyone wanted. But declaring the entire system dead because of corruption is like saying we should throw out the Bible because some pastors abuse their pulpits. Flawed people in positions of power do not prove the system itself is invalid. They prove the need for constant accountability, which is what the Constitution provides.
But that's just it. The Constitution isn't being honored. It's being bypassed by agencies and manipulated by private interests. You can't vote out a Pfizer executive. You can't remove Google's content moderation team. You can't appeal to Fauci's office when emergency powers are weaponized. This is not about bad apples. This is about a rigged orchard that now feeds an entire legal and financial structure built around debt, illness, surveillance, and control. Even the vaccine, sold under fear, was less about public health than creating a generational client base for the medical-industrial complex. You think that's hyperbole? What better business model than one that ensures nearly every citizen is a lifelong subscriber to treatment?
That argument strays from constitutional reasoning into conspiratorial determinism. Yes, big pharma influences policy, but citizens have refused mandates, filed lawsuits, and even won court injunctions. State legislatures pushed back. Governors stood against federal pressure. That is evidence of a working system, not a dead one. And to your theological point, yes, the Bible teaches that humans are corrupt, but it also teaches law, accountability, and stewardship. The founders understood this and built a government on distributed power and checks and balances. The corruption you speak of is real, but it doesn't prove the system is illegitimate. It proves it's under siege, but still recoverable.
But you keep saying recoverable. How? When did a meaningful rollback of executive power ever happen? When did a major corporation face criminal prosecution for colluding with government agencies to suppress speech or distort markets? Instead, what we see is a symbiosis of state and corporation, where the debt of the people funds the profit of the elite and the mechanisms of law enforcement are turned inward, even weaponized against a sitting president. That's not checks and balances. That's a hostile takeover, clothed in the appearance of legality.
Then let's work within the law to dismantle the overreach, not retreat into fatalism or throw around corporation as a catch-all for dysfunction. Yes, 2020 exposed rot, but exposure allows reform. Real Americans still protest, legislate, vote, and sue. The courts haven't collapsed. The Constitution isn't null. It's under pressure, but not replaced.
Respectfully, the Constitution is being held up like a retired sports jersey, admired, quoted, but no longer in play. When multinational interests determine policy, when emergency becomes the new normal, and when every right must be purchased, licensed, or consented to through adhesion, that's not self-government. That's corporatized servitude. The founders warned us never to trust government. The Bible warns us not to trust man, and 2020 showed us why. Let's zero in on one of the clearest signs of corporatization: the courts themselves. Walk into a courtroom today, and you'll likely face an administrative proceeding, not a true Article III judicial court. The judge often plays all roles: prosecutor, adjudicator, and enforcer. You're presumed to be a legal fiction, the corporate person, named in all capital letters, and the court acts as a commercial tribunal, not a constitutional venue. Add to that the requirement to be licensed just to access basic rights, like traveling freely, driver's license, earning a living, business license, or even parenting, family court cases, and you've got a jurisdictional bait and switch. Rights have become conditional privileges enforced under color of law.
You're conflating administrative courts with commercial tribunals. Yes, certain proceedings, like traffic court, family law, or tax disputes, are handled in administrative settings. But that doesn't mean they operate outside the Constitution. Every one of those courts is subject to judicial review, appeal, and due process requirements. As for licensing, that's not a violation of your rights. It's regulatory oversight for the common good. Driving a car or opening a restaurant affects public safety. The Constitution doesn't forbid licensing. In fact, it leaves most such regulatory powers to the states.
But what happens when that oversight becomes control? When courts deny standing, impose fees before due process, or presume guilt based on a failure to file the right paperwork? That's not justice. It's commercial compliance. And let's not pretend due process exists when most family court cases are held in private, where constitutional protections are routinely sidestepped. The courts act as debt collectors for the state. If you don't pay your fines, they suspend your license, not because you've harmed anyone, but because you violated a corporate policy disguised as law.
But if you believe a law is unjust, you can challenge it. You can appeal, sue, vote, or lobby. The fact that you're given an opportunity to contest even licensing requirements proves you're not in a corporate contract system. You're still within the legal framework of a democratic republic. And the all-caps name theory? It's a misreading of formatting conventions. There is no separate corporate entity being prosecuted. That's been repeatedly rejected by courts in every state. You are not a legal fiction. You are a citizen with enforceable rights.
What about the UCC presumed consent model? Most people don't know they've entered into a commercial contract when signing a license application or registering a vehicle. But those forms have fine print, legal clauses, and adhesion terms. The entire system is structured so that you waive rights by default, without full disclosure. How is that different from predatory banking? How is that constitutional governance? You shouldn't have to opt out of tyranny. You should be presumed free unless you consent otherwise.
You're correct that informed consent is essential, but let's not exaggerate what these systems are. A driver's license doesn't nullify your right to travel. It regulates your use of public infrastructure in a way that promotes safety. And yes, forms have legal terms, because we're a society governed by laws, not chaos. The Constitution doesn't guarantee lawless liberty. It guarantees liberty under law. Where there is overreach, challenge it. Where there's ambiguity, clarify it. But don't conclude the system has been replaced with a corporate trap just because you dislike the paperwork.
But when everything becomes paperwork, the burden shifts from the government to you, the supposed sovereign. That inversion is the heart of the fraud. The founders intended for government to have limited delegated authority. Instead, it now has presumptive authority, and the citizen must continually prove their innocence, prove their identity, and comply with endless regulations, all of which operate under a contract-based legal fiction, not natural law. And when you challenge that in court, you're met not with a jury of your peers, but with bench rulings, sealed records, and clerks enforcing policy.
Ladies and gentlemen, throughout this debate, the affirmative has offered a powerful and passionate case, but one built more on disillusionment with the system than on hard legal transformation. They've pointed to legitimate concerns, government overreach, corruption, influence by corporate interests, and the abuse of emergency powers. But they've drawn the wrong conclusion, that these flaws prove the United States has become a corporate entity in place of a constitutional republic. Let me be clear, corruption is not corporatization. Administrative complexity is not tyranny. Emergency power abuse is not legal metamorphosis. Yes, courts sometimes operate under administrative law, but they remain bound by judicial review, constitutional limits, and public accountability. Yes, we require licenses to drive or do business, but these are regulatory tools, not chains of corporate servitude. The licensing process can be challenged in court, reformed through legislatures, and resisted by public advocacy. Most importantly, the very fact that we're here, debating this openly, is proof that the Constitution still lives. Free speech has not been corporatized. Dissent has not been outlawed. Justice is still accessible. The problems we face are real, but they are the problems of a republic in need of reformation, not a republic that has been replaced. The Constitution has not been abolished. It has been neglected, and that's a challenge we the people must answer, not by retreating into defeatism, but by reasserting our role as citizens, not corporate assets. We respectfully oppose the resolution.
Ladies and gentlemen, we've presented a clear and disturbing truth. Through war powers, emergency declarations, regulatory licensing, and unchecked executive authority, the United States government has undergone a quiet transformation. While the language of liberty remains, the mechanisms of control have changed, and today they more closely resemble those of a corporate syndicate than a constitutional republic. The negative would have us believe that the Constitution is still functioning because it's still printed, still cited in court, and still spoken of in public. But a document not enforced is no different than a contract not honored. We don't judge a system by its slogans, we judge it by its fruits. And what are the fruits of this system? Perpetual emergencies, private interests writing public policy, citizens presumed to be corporate fictions, regulated through contract law and adhesion agreements, licenses for rights, fees for existence, and compliance as the price of liberty. A judicial system that rarely protects natural rights but enforces commercial obligations. A media apparatus and tech sector acting in concert with the state, determining what speech is permitted and what thoughts are disqualified. We've been told this is just complexity, not corporatization. But that complexity is the very veil used to mask the merger between state power and private profit. In the name of safety, commerce, and emergency, the people have been converted from sovereign principles into managed resources. And while the courts still open and the elections still happen, the real decisions are made far upstream, where wealth and access, not rights, determine outcomes. This isn't the republic the founders envisioned. This is a system that wears the costume of constitutional governance, but functions with the operating system of a corporation, hierarchical, self-preserving, and primarily interested in profit, power, and control. We are not merely governed. We are administered. We are not represented. We are managed. In this light, we must affirm the resolution, not because we want it to be true, but because we've seen too much to pretend it isn't. We respectfully affirm